The Labor Code of the Philippines, Book 1, Pre-Employment, Article 14, Employment Promotion. The Secretary of Labor shall have the power and authority, A, to organize and establish new employment offices in addition to the existing employment offices under the Department of Labor as the need arises. B, to organize and establish a nationwide job clearance and information system to inform applicants regarding registering with a particular employment office of job opportunities in other parts of the country as well as job opportunities abroad. C, to develop and organize a program that will facilitate occupational, industrial, and geographical mobility of labor and provide assistance in the relocation of workers from one area to another. And D, to require any person, establishment, organization, and institution to submit such employment information as may be prescribed by Secretary of Labor. Article 15, Bureau of Employment Services. A, the Bureau of Employment Services shall be primarily responsible for developing and monitoring a comprehensive employment program. It shall have the power and duty, 1, to formulate and develop plans and programs to implement the employment promotion objectives of this title. 2, to establish and maintain a registration and or licensing system to regulate private sector participation in the recruitment and placement of workers, locally and overseas, and to secure the best possible terms and condition of employment for Filipino contract workers and in compliance therewith under such rules and regulation as may be issued by the Minister of Labor. 3. To formulate and develop employment programs designed to benefit disadvantaged groups and communities. 4. To establish and maintain a registration and or work permit system to regulate the employment of aliens. 5. To develop a labor market information system in aid of proper manpower and development planning. 6. To develop a responsive vocational guidance and testing system in aid of proper human resources allocation. And 7. To maintain a central registry of skills except seamen. B. The regional offices of the Ministry of Labor shall have the original and exclusive jurisdiction over all matters or cases involving employer-employee relations, including money claims, arising out of or by virtue of any law or contracts involving Filipino workers for overseas employment except seamen, provided that the Bureau of Employment Services may, in the case of the National Capital Region, exercise such power whenever the Minister of Labor deems it appropriate. The decisions of the regional offices of the Bureau of Employment Services, if so authorized by the Minister of Labor as provided in this article, shall be appealable to the National Labor Relations Commission upon the same grounds provided in Article 223 hereof. The decision of the National Labor Relations Commission shall be final and unappealable. C. The Minister of Labor shall have the power to impose and collect fees based on rates recommended by the Bureau of Employment Services. Such fees shall be deposited in the National Treasury as a special account of the General Fund for the promotion of the objectives of the Bureau of Employment Services, subject to the provisions of Section 40 of Presidential Decree number 1177. Article 16, Private Recruitment. Except as provided in Chapter 2 of this title, No person or entity other than the public employment offices shall engage in the recruitment and placement of workers. Article 17. Overseas Employment and Development Board. An Overseas Employment Development Board is hereby created to undertake, in cooperation with relevant entities and agencies, a systematic program for overseas employment of Filipino workers in excess of domestic needs and to protect their rights to fair and equitable employment practices. It shall have the power and duty: 1. To promote the overseas employment of Filipino workers through a comprehensive market promotion and development program. 2. To secure the best possible terms and conditions of employment of Filipino contract workers on government-to-government basis and to ensure compliance therewith. 3. To recruit and place workers for overseas employment on a government-to-government arrangement and in such other sectors as policy may dictate. And 4. To act as Secretariat for the Board of Trustees of the Welfare and Training Fund for Overseas Workers. Article 18. Ban on direct hiring. No employer may hire a Filipino worker for overseas employment except through the boards and entities authorized by the Secretary of Labor. Direct hiring by members of the diplomatic corps, international organization, and such other employers as may be allowed by Secretary of Labor is exempted from this provision. Article 20. Uh, Article 19, superseded by VP Bilang 79. Article 20, superseded by Executive Order 797. Article 21, Foreign Service Role and Participation to provide ample protection to Filipino workers abroad. The labor attaches, the labor reporting officers duly designated by the Secretary of Labor and the Philippine diplomatic or consular officials concerned shall, even without prior instruction or advice from the Home Office, exercise the power and duty: A. To provide all Filipino workers within their jurisdiction as assistance on all matters arising out of employment. B. To ensure that Filipino workers are not exploited or discriminated against. C. To verify and certify as requisite to authentication that the terms and conditions of employment in contracts involving Filipino workers are in accordance with the Labor Code and rules and regulations of the Overseas Employment Development Board and National Seamen Board. D. To make continuing studies or researches and recommendation on the various aspects of the employment market within their jurisdiction. E. To gather and analyze information on the employment situation and its probable trends and to make such information available. And F. To perform such other duties as may be required of them from time to time. Article 22. Mandatory remittance of foreign exchange earnings. It shall be mandatory for our Filipino workers abroad to remit a portion of their foreign exchange earnings to their families, dependents, and or beneficiaries in the country in accordance with the rules and regulations prescribed by the Secretary of Labor and Employment. Article 23 repealed. Article 24 repealed. Chapter 2. Regulation of Recruitment and Placement Activities. Article 25. Private sector participation in the recruitment and placement of workers. Pursuant to national development objectives and in order to harness and maximize the use of private sector resources and initiative in the development and implementation of comprehensive employment program, the private employment sector shall participate in the recruitment and placement of workers, locally and overseas, under such guidelines, rules, and regulations as may be issued by the Secretary of Labor. Article 26. Travel agencies prohibited to recruit. Travel agencies and sales agencies of airline companies are prohibited from engaging in the business of recruitment and placement of workers for overseas employment, whether for profit or not. Article 27, Citizenship Requirement. Only Filipino citizens or corporations, partnerships, or entities at least 75% of the authorized and voting capital stock of which is owned and controlled by Filipino citizens shall be permitted to participate in the recruitment and placement of workers locally or overseas. Article 28, Capitalization. All applicants for authority to hire or renewal of license to recruit are required to have such substantial capitalization as determined by the Secretary of Labor. Article 29. Non-transferability of license or authority. No license or authority shall be used directly or indirectly by any person other than the one in whose favor it was issued, or at any place other than that stated in the license or authority be transferred, conveyed, or assigned to any other person or entity. Any transfer of business address, appointment, or designation of any agent or representative including the establishment of additional offices anywhere shall be subject to the prior approval of the Department of Labor. Article 30. Registration fees. The Secretary of Labor shall promulgate a schedule of fees for the registration of all applicants for license or authority. Article 31. Bonds. All applicants for license or authority shall post such cash or security bond as determined by the Secretary of Labor to guarantee compliance with prescribed recruitment procedure, rules and regulation, and terms and conditions of employment as may be appropriated. Article 32. Fees to be paid by workers. Any person applying with a private fee-charging employment agency for employment assistance shall not be charged any fee until he has obtained employment through its efforts or actually commenced employment. Such fee shall be always covered with the appropriate receipt clearly showing the amount paid. The Secretary of Labor shall promulgate a schedule of allowable fees. Article 33. Reports on employment status. Whenever the public interest requires, the Secretary of Labor may direct all persons or entities within the coverage of this title to submit a report on the status of employment, including job vacancies, details of job requisitions, separation from jobs, wages, other terms and conditions, and other employment data. Article 34. Prohibited practices. It shall be unlawful for any individual entity, license or holder of authority, A. to charge or accept directly or indirectly any amount greater than that specified in the schedule of allowable fees prescribed by the Secretary of Labor, or to make a worker pay any amount greater than that actually received by him as a loan or advance. B. To furnish or publish any false notice or information or document in relation to recruitment and or employment. C. To give any false notice, testimony, information, or document, or commit any act of misrepresentation for the purpose of securing a license or authority under this code. D. To induce or attempt to induce a worker already employed to quit his employment in order to offer him to another unless the transfer is designed to liberate the worker from oppressive terms and conditions of employment. Article 35. Suspension and or cancellation of license or authority. The Minister of Labor shall have the power to suspend or cancel any license or authority to recruit employees for overseas employment for violation of rules and regulations issued by the Ministry of Labor, the Overseas Employment Development Board, or for the violation of the provisions of this and other applicable laws, general orders, and letters of instruction.